Judiciary system in India. In a democracy, an important and independent judiciary is a necessity. It is the guardian of the constitution, which is the supreme law of the land. The Indian judicial system is a single unified system. The constitution has provided for an independent judiciary headed by the Supreme Court, below which there are the high courts at the level of the state and subordinate courts at the district level. The whole setup works like a pyramid. All courts in India function under the direction and control of the Supreme Court of India. The Supreme Court is the highest court in the country, which looks into the functioning of the courts below it. If a person is unhappy with the judgment of a lower court, he can move up the ladder and appeal to the higher court. The court deals with two types of cases, civil and criminal. All cases which are related to property matters, damage of goods, etc., come under civil cases, and the cases of theft, robbery, murder, etc., come under criminal cases. Criminal Procedure Code provides that trials be conducted publicly except in certain cases involving state secrets. No person can be arrested without warrants except in cases where delay may cause problems. An independent judiciary is a must in a democracy so that judges can discharge their duties impartially without any pressure from the legislature or executive. This is the reason why judges are not appointed by the government, and a hike in their salaries and other benefits are not in the hands of the government. An independent judiciary does not mean that justice is meted out arbitrarily. The judiciary has to follow the rule of law. It means that the same laws apply to all citizens, or in other words, it means equality before law. The Supreme Court. The Supreme Court is the highest authority of law in our country. It is situated in New Delhi. It has one Chief Justice and 25 other judges. The President appoints the Chief Justice, and with his consultation, he appoints other judges of the Supreme Court. For appointment as a judge of the Supreme Court, a person must be a citizen of India. He should have served as an advocate in a high court for at least 10 years, or as a judge in high court for 5 years, or he should be a distinguished jurist in the eyes of the President. The judges of the Supreme Court hold office till the age of 65 years. Once appointed, they cannot be easily removed from their office. If found guilty, they can be removed by a process called impeachment. A motion to this effect is passed by the Parliament. The procedure for the removal of a judge is made very complicated, which bears testimony to the fact that since independence, no judge has ever been removed from this office. This is done to ensure that judiciary works independently. The Chief Justice and other judges of the Supreme Court are paid handsome salaries and given many benefits and allowances. The objective behind this is to prevent corruption, powers, and functions. The Supreme Court is the apex court of our judicial system. It has wide jurisdiction of powers which can be divided into original, appellate, and advisory. Original jurisdiction. In certain cases, the Supreme Court is the sole authority to discharge the function. Such cases originate in the Supreme Court only, which include the disputes between two state governments, or the disputes between the central and the state government, or the disputes between the central government and some of the state on the other hand. It also includes the cases involving the violation of the Constitution. Appellate Jurisdiction. As Supreme Court is the highest judicial body, it hears appeals against the judgment of the High Court. It can also review its own judgment. It hears appeals when a High Court certifies that a particular case should be tried in the Supreme Court. Moreover, when a High Court reverses the decision of the lower court and awards death punishment, an appeal can be made in the Supreme Court. Advisory function. The President can consult Supreme Court for legal advice on public issues. However, this advice is not binding on the President. The Supreme Court is the court of records. All decisions and proceedings are recorded and printed. The lower courts in similar cases can refer to these decisions. Judicial review. The Supreme Court has the power to review the laws passed by the legislature or the orders issued by the executive and check whether they are in accordance with the provisions of the Constitution. If the orders or law is in violation of the Constitution, the Supreme Court can declare them null and void. High courts. Below the Supreme Court are the high courts at the level of states. Sometimes two or more states share a high court, for example, Punjab and Haryana. The high court comprises a Chief Justice appointed by the President in consultation with the Chief Justice of India and the Governor of the state. The number of judges in High Court varies according to the size of the state. The Chief Justice and other judges of High Court remain in office till the age of 62. For appointment as a judge of High Court, a person should be a citizen of India. He should have worked as a judge in a court for at least 10 years or as an advocate in the High Court for 10 years, or he should be a distinguished jurist in the eyes of the President. He can be removed from office by the President of India on receiving a motion passed by the Parliament. Powers and functions. The High Court is the highest court of justice in a state. Its original jurisdiction includes matters related to fundamental rights and disputes related to state elections. The High Court hears appeals in civil and criminal cases decided in the subordinate courts. It controls and supervises the working of the lower courts. It maintains a record of all its decisions and proceedings which are quoted by the lawyers and judges in the subordinate courts. Subordinate courts. They include courts at the district level and below. There are different courts in the district to try civil and criminal cases. Civil cases are tried in the court of a district judge. These courts can also hear appeals against lower courts. Smaller civil cases are tried by munsifs in the lower courts. Criminal cases are tried in the Court of Session Judges. The district judge acts as the district and session judges. Criminal cases are also heard by magistrates in the lower courts. The judges of the subordinate courts other than district judges are appointed by the governor from the state judicial services. They are recommended by the State Public Service Commission. Their pay and allowances are decided by the state government. Lok Adalats. Lok Adalats are made for providing cheap and speedy justice to the poor. It has simplified the legal procedure. They are presided over by the retired judges. The disputing parties present their cases and matter is settled without a pleader. The first Lok Adalat met in New Delhi in 1985 and 105 cases were settled in a single day. First Information Report (FIR). First Information Report is the information that a police officer receives about the commission of a crime. An FIR must be lodged in writing and duly signed, and the copy must be handed over to the informant. It is not essential that only the victim can file an FIR. Anyone who knows about the commission of a cognizable offence can file an FIR. Moreover, a police officer who comes to know about a cognizable offence can himself file an FIR. It must contain the place, date, and time of the incident. A detailed description of the incident is not necessary. The FIR has to be filed at the police station under whose jurisdiction it falls. The FIR should have the narration correctly. Incorrect documentation may weaken the case. The courts and the police play a vital role in the administration of justice, but their role is quite different to each other. The courts try to provide justice to the people and punish the guilty. They try to verify the facts and hear the arguments of both the parties. If one party is not satisfied with the verdict, it can appeal in the next higher court. Public prosecutors are the gazetted officers appointed by the state to help in the prosecution of offenders to keep the society free from crimes. The present criminal system is based on the principle that any crime committed by an individual is a crime against the society. Therefore, the prosecution and punishment of the crime is the responsibility of the state. Such prosecution on behalf of the state is performed by a public prosecutor. During the investigation stage and till the filing of the charge sheet, the investigating agency is in control of the proceedings. Both play a complementary role in the judicial system. Another category of cases that have caused much controversy in recent times are public interest litigations (PIL). Due to financial crunch, poor people lack the ability to go to court to get justice. A socially concerned organization or group can approach the court on behalf of the poor. Even a postcard or letter written to court could serve as a writ petition. The court, after investigation, can pass necessary orders. This kind of litigation has helped the poor to get speedy and inexpensive justice, although it has led to confrontation between the executive and judiciary. This is due to increasing judicial activism.